Perfect. This hearing is in the matter of case number CFI 085-2023 before Justice Sir Jeremy Cooke. The hearing is being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry on the judge's instructions. The claimant is represented by Amareller Legal Consultants. Lead counsel is Jonathan Noble. The defendant, Cooke & Co. Restaurant LTD, is represented by FRM Legal Counsel LLC. Lead counsel is Mr. Faisal Khan. And I understand that the remaining defendants are litigants in person. But correct me if I'm wrong, Mr. Faisal Khan.
Presently, there are 3 defendants, and I am representing defendant 1, 2, and 3. So they are not acting in person so far.
Yes, and are you now registered as
Yes.
a practitioner?
So the issue is, in the morning we have submitted the required documents on record, and I have received a confirmation email that my application has been processed and the relevant payments have been made. That's what I was communicated.
Well, I'm not sure it's been processed as yet, but as I understand it, you have applied. Anyway,
Can I
yes,
clarify, Your Honor? The application has been currently processed for payment. So once the payment is done, we would then normally have an interview with the legal practitioner to finalize the registration. So that is where it's at the moment. So it hasn't been completely finalized, but it's in the process.
Yes, thank you very much. Well, I'm prepared to listen to you, Mr. Khan, but you have been tardy in making that application. Should have been dealt with long ago. Anyway, no matter. I will hear you regardless. The other question, at least on that basis, the other question which arises, Mr. Noble, arises in relation to the question of the late acknowledgement of service, doesn't it?
Yes, sir.
Yes,
Your Honor.
How does that arise under the rules?
Your Honor, Part 8 of the rules and Part 8.16.
Yeah.
So Part 8.13 requires the filing of an acknowledgement of service within 2 weeks of receipt of proper service.
Yeah.
Under Part 8.16, if a defendant has failed to file an acknowledgement of service and the time for doing so has expired, the rules are clear that the defendant may attend but may not take part in the hearing unless the court grants permission. And so, as we understand it, it's at the discretion of Your Honor as to whether to permit the defendants to participate in proceedings today.
Very good. Let me just have the dates clear. Service took place on what date?
Service took place, Your Honor, on
some 30th November.
Yes, sir.
30th November. So acknowledgements of service were due by mid-December.
Yes, sir. That's correct.
And were in fact filed on the 25th of December. Is that right?
That is correct, sir. By I believe defendants 2 and 3. Although there have been multiple acknowledgements of service filed, including one on the 9th of February by Mr. Khan. So I'm not certain whether the first defendant also filed at that time, but our understanding is that the initial acknowledgements of service were filed 11 days after the due date.
Right. And when was the first challenge made to jurisdiction?
The challenge to jurisdiction was made in those acknowledgements of service.
No. There has to be more than that. There has to be an application within 14 days under.
Yes, sir. That's correct. And those applications, we examined this as well. It looked like the applications were late by 1 day when we initially looked at this, but it appears that they were actually submitted through the portal on time. But we're only credited to the or we're only cited on the portal the day after. So in fairness to the defendants and to our colleagues, and in interest of fair play, we did not raise that as a point.
No, well, I'd worked that out for myself, that
Yes, sir.
9th of January was absolutely on the cusp. But because the acknowledgements of service are late, that means that the challenges to jurisdiction are out of time as well.
Indeed.
So what do you want to say about that, Mr. Khan?
So we were actually retained as legal representatives on 24th by the defendants, and the defendants did not receive the service until 12th of December. That's what the declaration was made by the defendant number 2 and 3 and defendant number 1 to me as a counsel. When the defendants made this admission that the service was not served upon them until 12th, I have advised to them that they have 14 days thereafter from the 12th of December. And immediately they have written to the DIFC courts asking how to file the acknowledgement of service. Thereafter, the DIFC courts have replied that they may get on board by filing an acknowledgement by accessing the service portal. The correspondence in this regard has been submitted to the courts for your kind attention. If you prefer, I can reference it in the paginations.
No, I don't need to go through all that. The position is this, Mr. Khan. I think there have been a number of defects in the procedure, but I don't want to decide this matter on the basis of procedural issues. So I'm prepared to hear you, and we'll deal with the substance of it.
Thank you, sir.
All right. Mr. Noble, where do you want to start? It's your application first. There is an application for to challenge the jurisdiction, but it probably makes sense for you to deal with everything in the round first of all, and then Mr. Khan can have his say, and we'll see where we get to at that point. I've read the papers, so I'm pretty familiar with it. There's a question I want to ask you, Mr. Noble, which is this. I'm unclear from your case and the evidence that's produced whether in fact the evidence shows that there was an agreement to repay or to pay, I should say, 1.3 million following the failures to pay the original sum of 1.1 less the 100,000 that was actually paid. So I want to know exactly what your case is about that. And in particular, I'm interested not just in all the WhatsApp exchanges that I have read, but also in what is said in the affidavit that was sworn in support of the freezing injunction. And looking at paragraphs, well, basically it's paragraphs 30 through to 42.
Can you give us one moment, Your Honor, to familiarize ourselves, to refamiliarize ourselves with those paragraphs?
Yeah.
And can you cite those paragraphs one more time, sir?
Well, it's the whole section of his affidavit that deals with the facts, but what really interests me is paragraphs 30 onwards. If you go back to paragraph 26, what he says is that the second defendant suggested a repayment plan of 100 to 200,000 a month. And on the 29th of October, he agreed to that proposed repayment plan. There was then a failure to make the first payment at the beginning of November, but in fact, a payment was made on the 24th of November. And then thereafter, there are various exchanges. And if one looks at all the WhatsApp exchanges, one can't see any agreement being reached at all, because there's an issue about whether or not post-dated checks are going to be supplied. So if you look at paragraph 30 onwards, and particular paragraph 33, there's an offer of a repayment plan for 13 months with 100,000 dirhams to be paid, but the counter offer is for 200,000 and also wanting post-dated checks. There's no agreement on 200,000 a month, and there's no agreement on post-dated checks. So the question is there an agreement ever for anything more than the original 1.1 million less the 100,000 that's been paid in November?
I think that your reading facially is correct, that what we have on April 29th is an offer from, sorry, Ron, I'm just consulting the documents. What we have is an offer, which basically is that because there was no payment for so long, that the offer was to repay 1.3 million in total, plus the 100. And the acceptance is simply in the line right underneath that. Can we please start this month? That is, yes, I'm happy to proceed on the basis of repayment of the terms, but I have a counter offer, which is that I want 200K a month and I want checks.
Where are you reading from?
So the very next line, if you go to the exhibit, Your Honor, on April 29th, the very next line is, can we please start this month? And 200K. I can't wait that long for it. Khaled, really, I can't wait 13 months. So I think that there is an acknowledgement or an acceptance, Your Honor, and I think that we have to take a step back. Obviously, as Your Honor and counsel would have probably papered this document in a very different way if we were aware of where this transaction would have ended up. But this was a conversation between, as you can tell, two very good friends who shared family matters and personal matters together, as well as business. And so there was a lack of the formalities that legal practitioners may expect to see. But I think it's very simple. The response is, can we please start this month? That is, yes, fine. You want to pay me more than what the principal that's owed? We're happy to accept that, Your Honor, Khaled. But here's my counter offer. I want 200K. I can't wait 13 months for you to repay me. And I want security checks because of what's happened. So there was never subsequent discussion about the repayment of 1.3 million. The discussion or the lack of a meeting of the minds, Your Honor, was around provision of security and the amount and duration of repayment. And the conversation goes on sometime. Please, let's start this month. Make it work. This is my client again. This exchange goes on for quite some time on April 29th.
Yeah.
And so I think the answer to you is that, of course, offer and acceptance in the form of a signed agreement is something that would ameliorate your concerns. But in the context of
I'm not concerned about formal offers and formal acceptance. It's plain to me, and I'll hear Mr. Khan on the point, but it's plain to me that there was an agreement to a loan. And the only question is, what was the ultimate position reached in relation to agreement as to terms of repayment? And it's quite hard to work out, reading that complete exchange on the 29th, where they finish up.
I think that's right, and I think that's fair, Your Honor, in regards to the issue of the amount per month and the duration and provision of security checks. I don't see anywhere in here further discussion or negotiation on Khaled's offer to repay 1.3. That I think is settled, And in fact, Khaled keeps offering equivalent to one. So if you see here, if a month passes, I can't give you checks. Basically, what he's saying is, I won't be able to run my business if you bounce a check.
Yeah.
The small payments I can manage. I can give you checks. It's not a problem. Equivalent to 1.3, or give me an extra 700K, and I give you the full 2 million check amounts. Just let me know whatever works for you. So the issue of 1.3 million, I think, is resolved and agreed upon by the parties in this exchange. There is, I think, there was a lack of agreement, and that's why we've ended up in this situation about how the terms of repayment move forward.
Yeah. The very last, I mean, the conversation comes to an end, and I hope I've got the right page. I'm going on. There's the next entry is the 4th of May. Is that right?
No, I see an additional entry on the 30th of April. But that may just be that it continues on.
Oh, yes, I've got it. Yeah. Is that the one beginning the money's supposed to be for you, or does it go back further than that?
Yes, the money's supposed to be for, that's correct. So I think, and I don't know whether, it looks to me.
02:30 in the morning, yes.
Yes, that this conversation went on.
Yes, it's going on
throughout
very
the
late.
day and late into the evening.
What is it, late at night? Is it? I don't know what time
again,
zone we're on. It's 01:38.
I believe this is Pacific Standard Time, because Mr. Saleh is sitting in Los Angeles having these conversations with Mr. Fadli.
Yes, I see. Yes, so it's all one.
So it would have been 2:30 in the morning in Los Angeles, and 2:30 or 1:30 p.m. depending on the time of year here in Dubai.
Yes, I see. All right. Well, I have your case on that.
Yes, sir. Yes, Your Honor.
I don't think for the moment I need to hear from you further. I'll hear Mr. Khan on what he's got to say about jurisdiction first, and then he can say whatever he wants to say about the agreement and who's party to it, and so on and so forth.
Sure. First and foremost, the defendant 2 and 3, they are raising jurisdictional objection, not the defendant 1 made, please, Your Honor. Defendant 2 and defendant 3 are not licensed institutions in accordance with Article 5.1 of the Dubai Law 12/2004. If upon reading the article, it clearly stipulates that licensed institutions of the center are in the scope and ambit of the DIFC codes. And further, 5.1b requires that commercial actions arising from or related to executed contracts or concluded transaction shall fall within the purview of the DIFC codes. The meaning which the article is ascribing here is for the commercial licensed institutions who are executing the contracts and concluding transactions. So the entire meaning from our understanding is it is limited to the commercial transactions and commercial institutions. So on that basis, defendant 2 and defendant 3 are not licensed institutions, and they are private individuals. So in that respect, defendant 2 and defendant 3 are applying for a jurisdiction challenge, requesting the Honorable Court to dismiss this application in this regard. Further, to support its position, if it may please Your Honor, page number 43 of the pagination of the hearing bundle submitted by the defendant. It, if you read on it, there's a clear agreement between the parties whether this loan itself is a personal loan or a company loan.
Yeah.
The agreement is clear, where Saleh and Khalid are exchanging messages saying that, do you want this loan contract to be personal or company? Khalid has confirmed again, and Saleh has ratified that. So the question as to whether the loan is personal loan or commercial loan is clear for us that this was a personal loan. And as my able counsel also pointed out earlier, they are friends and family relationships, yes, and they supported each other. So in this regard, our position is that defendant 2 and defendant 3 should be outside the scope of the DIFC courts. And in this connection as well, the defendant 2 and defendant 3 has filed a local court case in the Dubai courts. The reference to that case has already been attached to the hearing bundle, on the fact that as you also rightfully said, Your Honor, that the total amount due is 1 million out of 1.1 million after deducting the 100,000. This 300 on top of this is clearly an interest, which is not permissible as per the UAE local laws. The public policy of the UAE laws do not permit interest to be adduced between two individuals. And for that reason, the defendant number 2 has filed a case in the local court requesting the court to nullify the agreement based on the fact that this is against the public policy. So on this basis, the defendant 2 and defendant 3's position is there is no jurisdiction on them as their individuals. So this is in relation to the jurisdictional objection application. In relation to defendant 1's position, whether there is contractual privity, whether defendant 1 should be dragged in this case or not, is clearly adduced in page 43. As I mentioned earlier, this is a personal loan, not a company loan. And this can also be adduced in page number 61 of the pagination, where Mr. Saleh himself is confirming that I have, as a friend, granted you the loan. So this is clearly mentioned in various annotations. Page number 61, if you may read that, if you want me to go through that. And also I would like to give you an initial understanding between the parties. The initial understanding is that Mr. Saleh and Mr. Khalid, as they were friends, initially agreed that let us apply for a financial loan together. But since Mr. Saleh's reputation and his corporate or his company was having some credible documentation in relation to the application of the loan, initially Mr. Saleh has requested Mr. Khalid to apply on his behalf for a 2 million dirhams loan. That loan was initially granted, and relevant pages from page number 17, 18 and 19 of Exhibit D1 of the pagination clearly establishes that documents were exchanged. But that loan, even though it was granted or approved by the bank, which was First Abu Dhabi Bank, that loan was never distributed or taken because of the fact that the interest rate was higher. Then what Mr. Saleh did was he transferred the money from his personal accounts. Initially an amount of 200,000, then 300,000 in 3 tranches. There were 4 transactions that were performed, but not from the loan that he took and he wanted to transfer. He transferred from his personal account. So all in all, this supports the fact that this was a personal loan. Later, the question about whether 1.3 million is due or not, if you see pagination number 34, page 34, Mr. Saleh is clearly confirming that 1.1 million is the due amount, not 1.3. Please give my 1.1 million. If you allow me, I can read the exact wordings for you.
Well, it's all right. I've read through all the material, so I'm familiar with it. And at one point he says, I'm not interested in interest. I just want my money back.
Yes, that's what he originally proposed. Later, he asked for interest as well. And if you notice, sir, there were a lot of missed calls and voice chats between the parties. They had a lot of discussions, and those voice calls and discussion added to this fact. They were exchanging. Whenever Khalid was asking for interest, Saleh told that please call me. So this all adducing and adding to the entire facts.
Well, Mr. Khan, I'll ask you the same question. I'm very conscious that in addition to the WhatsApp exchanges, there were telephone calls, but the only evidence that really I've got about that is contained in Mr. Al-Maskan's affidavit. So the question is, what am I to read in that as to what the final agreement was?
Sir, if you allow me, sir, I can get a similar affidavit from Khalid himself.
Too late. Too late. You should have done that long ago. I've got to proceed today on the evidence I've got in front of me. I've extended to you every possible indulgence procedurally. So I'm going to decide this case on what I've got. And what I've got essentially are the WhatsApp messages and this affidavit. And that's the only direct evidence of what the agreement was between the parties. I mean, leaving aside the jurisdiction point for the moment and everything else, if one looks simply at the question of a loan, there can't be any doubt that someone, the first defendant, second defendant, I think we can rule out the third defendant because I can't see anything in the third defendant's WhatsApp messages that puts liability on her. She's the second defendant's wife, I take it. Is that right?
Yeah, that's right.
Yeah. So either the first defendant or the second defendant owes money on a loan. An agreement has been reached, and certainly there was 1.1 million initially, 100,000's been repaid. And the question is simply, what was the agreement following the failure to pay within the anticipated rough time over which it was hoped the bank loan would be obtained that would replace the loan that had been given to tide the defendants over. So what am I meant to make of Mr. Get his name right, Mr. Al-Maskan's affidavit? Do you want to make any submissions about that?
If you allow me, sir, I would be able to submit a submission.
Well, now, I mean.
In relation to Mr. Khalid's position, when I made him read the affidavit, he clearly denied the facts stated in the affidavit, and he has clearly mentioned that this is not a right or a correct way to substantiate. He's not in reiterating the correct information. That's what his position is.
All right. Okay. Is there anything else you want to say at this stage?
Thank you.
I need to ask you one question. Sure. In relation to jurisdiction. If you look at Article 5A(1)(c) of the Judicial Authority Law,
sure,
what it covers is civil or commercial claims arising out of or relating to any transaction which has been wholly or partly performed within the DIFC. Now, why doesn't this loan fall into that category? A claim on this loan.
Sure. Thank you for asking this question. First of all, this is not a commercial loan. This is a personal loan. This is our position.
I understand that. But it's still it's still a civil claim.
Number two, a civil claim in relation to the fact that if it is concluded within the DIFC and there is no evidence as such that they were sitting in one of the DIFC cafeterias or coffee shops having a discussion about the loan, as Mr. Jonathan confirmed that he's sitting in Los Angeles having a WhatsApp conversation with a person who is outside the DIFC court. Thirdly, there is nothing in relation to the fact that this money was being used for a commercial purpose or for something related to a private, for a company. This is something between two individuals, and this particular article does not fall because of these reasons.
Right. Well, the payment of 200,000 dirhams is made to the first defendant's bank account, and the first defendant is a DIFC licensed establishment, isn't it?
That's right. And there is a background to it as well. If you allow me, I can answer that.
Yeah.
Sure. So at that time, when 200,000 was paid in Cooke and Company's bank account, a DIFC licensed institution, Mr. Khalid was in Paris at that time. and relevant evidences are available on record. If you allow, I can submit that. And he was having the Russell Khema bank card in his possession while he was in Paris. And at that time, when 200,000 was requested, particularly 200,000, if you notice, he didn't ask for more or less, only 200,000, because he wanted to use those funds for his personal use in Paris. And because he had a card, he didn't have his personal bank account card. He had the RAG bank account card of Cooke & Co. For that reason, he requested that please transfer 200,000 in Cooke & Co. And he transferred. Later on, Waqas, the finance manager of Cooke & Co., he supplied that personal bank account details of Khalid. And thereafter, Saleh has transferred the remaining money into Khalid's personal account. That is also available on record as submitted by the claimants. So the position is that this 200,000 was part of the negotiation between two individuals, two persons, not licensed institutions, and that was spent on his personal expenses.
Yes, all right. Thank you. One last question.
So if you allow me, sir, before I make one more point I want to raise.
Yeah.
The 100K that was transferred back from Khalid's personal account to Salih's personal account.
Yes. Yeah.
Okay.
Okay. I've got before me an application notice dated the 9th of January 2024.
Sure.
Which is from the second defendant. Right. Do you have that to hand?
Yes, I have that at hand.
If you go to the section headed Part A, it says the applicant intends to apply for an order the DIFC courts have no jurisdiction. And then underneath that, it says because defendant 2 has consented in writing to submit disputes to DIFC courts, and DIFC 2 and defendant 2 is not a licensed body.
Right. I understand that, sir. This is being relied by the claimant in their in the support of the position. But
Yes.
Here the point is there was a typo error that not consented was intended to be filed. Because of that reason, it has been used. To support further on its position, acknowledgement of service, the first document that was submitted, it clearly says that jurisdiction, they intend to challenge the jurisdiction. I respect my learned counsel's understanding to this, but this was a typo error. Not consented was intended to be typed.
Well, that's what I'd rather thought, but it is rather a basic typographical error. Yes,
that's right.
All right,
Your Honor, we would note it's one that's also easily capable of remedy with the tribunal itself, both when it was raised by the claimant and when it was caught supposedly as a scrivener's error by the defendants.
Yeah, well, I'm not going to decide the case on that basis. I'm quite clear in my own mind the court does have jurisdiction, so I don't need to take a point about this. It on the face of it, it's an obvious error because it's inconsistent with what's being said elsewhere. But in my view, the court does have jurisdiction under Article 5A1C in relation to any person who is involved in this transaction, which is all about getting a loan for the purposes of the DIFC company and its supposed liquidity problems, hence all the questions about bank loans, mergers, investors, sale of shares and all the rest of it. So I don't have any difficulty with that at all. The only things I want to hear you further about, Mr. Noble, are these. As matters stand, my provisional view is that the agreement for the loan was an agreement between the second claimant and the second defendant, albeit that money was paid partly to the first defendant and its bank account. So if you want to seek to persuade me that there is either liability on the first defendant or third defendant, in addition to the second defendant, now is your opportunity. And I also need persuasion, if you've got anything more to add, that the right figure is not the figure of 1.2 well, 1 million dead as it now is, 1.1 less than 100,000, added to which you'd get interest. And if you got interest on that, what the appropriate rate of interest might be.
Your Honor, I'd humbly submit to you that if you had trained in the great state of Texas, you may take a different view to joint and several liability than the one that you're taking right now with regards to defendants 1 and 2.
Well, we are looking at DIFC law.
Yes, sir.
Not Texas
Your Honor,
law.
and I do understand that very clearly. But I think without getting to the issue, which we don't need to get to at this hearing today, of whether there was some sort of fraudulent inducement, the fact of the matter is that the defendant, acting as individually or in his capacity as a director, has obligated, because of the lack of clarity and because of the numerous representations that he's made, that this is both his liability and the company's liability. And we just go through 13th December, 8th of January, 29th of April. These are company liabilities. These are liabilities of the company. This is a company liability. The company borrowed from your company. That it should not be, frankly, the claimant's responsibility or that it would be fundamentally unfair, given the way that this transaction unrolled with the WhatsApp text messages, to demand such precision. Mr. Al-Fadli, whether it was as a director or in his capacity as shareholder, and I would submit that at various times it was in both, obligated both the first defendant and himself to repayment of these debts. I understand, and I think that that's clear. I think that he's both claimed this as a personal liability, and my learned and esteemed counsel has made that argument very well for me. But he's also obligated the company, and I'm pointing to 3 instances in the WhatsApp correspondence that get us there. And so I think that it would be, frankly, too cute by half to say that while making representations about mergers, liquidity, cash flow, the need for this loan for a company, and obligating the company in writing to repayment, to then state that this is a liability that's that is several. I believe this is a joint and several liability of Mr. Khalid and of the company, and I think that they should both be held responsible for repayment. I think
your best references are those where the second defendant says he wants it documented as a loan to the company.
That's absolutely correct, Your Honor.
And I've seen that. There's an oddity here, because ordinarily one finds defendants saying, I'm not personally liable, only my company is, and seeking to get out from under on that basis. In this case, because of the jurisdiction point, the defendants are saying it's a personal obligation and not a company one. There's no doubt that at one time he was saying this ought to be documented as a company loan. But the question I have again is, where do I find agreement to that? The problem with all these WhatsApp is you've got a constant discussion going on without any clear agreement being reached. You don't get a straight yes, I agree that at some point, or we'd agreed about that, or anything of that kind. So if you want to take me to the bits that you rely on in the WhatsApp to suggest that the company is liable as well as the second defendant, now's your chance.
Yes, Your Honor. So I don't think I need to. Would you like me to guide you through our argument regarding the director's capacity to bind the company?
No. I don't have any difficulty at all about the fact that he could do it. The question is, does he? So
if you go back to our initial application, I think this is very clearly laid out in paragraph 51 and in a series of emails. So we start 13th December 30, 2022. Let me know if this is okay with you. I'll be sending you a document to sign which confirms that you give us this amount. It's a company liability. Their legal team will definitely want to see it. 8th January, I will send you a document that the company borrowed from your company this money. 17th January, the money loan contract that you gave me money. So again, there is now here a lack of clarity about which of these parties is the borrower. And I would submit to you, frankly, that lack of clarity means that they both must be liable jointly and severally for this obligation to repay. The 29th of April, he gets into the fact that if he gives you checks, if I give you checks, I won't be able to run the company. I won't get facilities. That is, that somehow if he personally obligates himself, which is what he wants to do, or the company personally obligates himself in either form, that they won't be able to run the company, that the company is a core participant and recipient and beneficiary of this loan. And I think I should go back to a very basic point. While I appreciate the hearsay evidence that opposing counsel introduced from Mr. Faisal from Mr. Khalid about what his state of mind was in Paris in relation to the Rack Bank ATM, it's clear that an initial 200,000 dirham payment was made to the corporate account of the DIFC company. And the corporate finance director of that company directed payment of the remaining amount to the shareholder and directors' accounts. Now, and so again, both in terms of receiving, i.e. the performance of this loan and obligations to repay, Mr. Khalid has at various times obligated both the company and himself. They both receive funds, and they are both, I would argue, jointly and severally liable for repayment of those funds.
In terms of enforcement, what difference is it going to make, Mr. Noble?
Well, I think it makes a great deal of difference, and we discussed this at some length when we at our first hearing on January 2nd. You have a company that has physical assets located within the DIFC, assets including bank accounts that we may be able to levy against. You have an individual who's represented multiple times, both that he needs these funds for ongoing cash flow and that he doesn't have money, yet continues to live a rather lavish lifestyle, vacationing in Paris, living in the Meadows villas in Dubai. The fact of the matter is that we have significant concern, given the bad faith that the defendants have shown over the course of the last year and a year plus, about a commitment to repay. And so we believe that being able to seek satisfaction from both parties and the assets that are under both parties' names are the only way that we can have a fair shot at receiving full recovery of the amounts that are owed.
Is he the sole shareholder in the in the first defendant?
Unfortunately, we don't have insight into that because the DIFC registrar doesn't show that. What we've understood and what I believe was reflected when I last looked into this is that there is outside investment and there is now a capital influx into the defendant, which would again help to further satisfy repayment of this loan obligation. But the defendants haven't been forthcoming with the corporate documents, and so I don't have any evidence on that.
He's resident in Dubai and in onshore Dubai, so that if judgment is entered against him here, you can transport that into onshore Dubai and enforce it there against him personally.
Ostensibly.
And against his shares in the company.
Ostensibly.
Yeah, well, I appreciate though. Who knows what problems may arise. Yes.
I'm sure that Mr. Khan will help us down the path of facilitating problems.
Yes. If I'm against you as to the 1.3 million, but with you as to 1 million, what do you say the appropriate rate of interest would be? And from when should it run?
Your Honor, we would argue that the appropriate rate of interest is the market rate of interest at the time that the loans were paid, which was June of 2022. and that the interest should run from until repayment is made in full. It hasn't been relevant to this because we haven't gotten to the question of damages, and there is this promise of repayment of 1.3 million. But Mr. Saleh did procure a commercial loan in part to make these payments. So there has been interest that he's been servicing to make these payments. Again, I haven't entered that into evidence and it's not relevant. You're asking me a question as to what we believe is appropriate. And I believe a minimum of 9%, but ostensibly what the market rate of interest was for a commercial loan at the time that the loan was granted in June of last year.
Well,
sorry, June of 2022. Pardon me, June of 2022.
Well, that raises the point. Under the original deal, on the evidence, repayment was expected. They're talking about 3 to 6 months, but hopefully the external loan, the bank loan, was going to come through within a month. If there's no agreement at any point to a different figure, the question is when interest should run from, and maybe one's talking about sometime later in 2022, because had everything gone smoothly, had there been no issues, there would have been a repayment within a matter of months of the full sum, but without any interest, because that was the deal. And so the question is, when should interest actually run from in that circumstance?
Your Honor, I guess I'd like to make an ancillary point, but one that's relevant to this. Mr. Saleh, and Mr. Al-Maskin, you can see it very clearly in the correspondence, was not interested in interest. He saw this as sure, first and foremost a loan to help out somebody who he cared for. There have been significant legal fees that have been incurred as a result of having of the defendant's bad faith or recalcitrance to pay. I guess I can't say bad faith. Properly awarding those legal fees is in some way more relevant or as relevant as the amount of interest awarded.
Right. Okay.
And the reason I say that is because I think that the amount of legal fees that have been incurred are frankly higher in some way than the amount of interest that will be awarded.
Yeah. Well,
in fact, I know that they are.
It's often the case when you don't have a substantial sum of money involved.
Yes, sir.
All right. Well, I think, is there anything else you want to say?
No, Your Honor. I appreciate that you may, in your judicial wisdom, seek to split the baby to find justice here. I would just encourage you in thinking this through to find as well that the parties did agree to repayment of 1.3 million dirhams. And so to take that into consideration, particularly given the documentary evidence in that regard.
Understood. Mr. Khan, is there anything else you want to say?
I rest my case, sir. I leave it to your able hands to determine exactly what the issues are and pronounce a decision. All
right. Well, I can tell you in essence what my decision is. I'm going to put it in writing, so there's no room for any misunderstanding. But it seems to me absolutely plain that the second claimant is entitled to recover from the second defendant. Whether he's entitled to recover 1 million or 1.3 million, I shall consider, and you'll get my reasoning on that in writing. I have no issues about the jurisdiction question. It seems to me plain that the court does have jurisdiction over all three defendants insofar as they're involved. But I don't consider that the third defendant, as the wife, ever gave any guarantee of any kind, so there's no liability on her. I will consider further whether or not there is room for liability on the part of the first defendant, and that'll come out in the written judgment in due course. My inclination, and I say this now and again, I'm going to think further about exactly how it works. My inclination is that there would either be repayment of the 1 million with interest running from a date sometime in 2022, when the original loan should have been repaid. The alternative would be, if I was to decide that 1.3 million was owed, is that there would be no interest running, because effectively the 1.3 million was there in order to compensate the lender without having an interest payment as such. So that's how it's going to work. The end result of that is that the second claimant will recover, and he must be entitled to his costs for so doing. Now, I don't suppose you haven't filed any schedule of costs, have you, Mr. Noble?
Not yet, Your Honour.
No. Well, that can all remain for the future. When you get my reasons and judgment, it will say that the claimant is entitled to his costs, his reasonable costs, and that they should be the subject either of agreement between the parties, or if they can't be agreed, then they'll have to be assessed by the registrar. All right. So that, I think, covers the position, and hopefully I'll get something to the courts later today, but it'll take the courts a while to process it, and you'll get the form of order and judgment in the course of the next week or so. All right. Thank you both very much. If you wouldn't mind signing out, I'll have a quick word with the associate.
I'd like to thank opposing counsel for their time, and also, Your Honour, your time today. Thank you very much, sir.
Thank you very much.